Okay, it's 7 o'clock in Alaska, and this is Free the People. Welcome, everybody. We're really excited tonight to have our much-anticipated guest, Ron Gibson. Thanks for being here, Ron.
Thank you for having me.
I'm going to go ahead and we were talking before the recording started, and I want to make sure that we don't lose the thoughts around that conversation. I think what we'll do is I'll go ahead and introduce you now, and we can get through some of the how-tos and the whys of land patents. And then for people who want to stay a little bit longer and bring that discussion back up, let's please do that in about an hour from now, if that sounds good to you.
Well, that's fine. I guess I have a question in that regard. How much time have I got? So that's going to have a bearing on what I think I can push into this time frame.
How much coffee do you have?
What was that, Chris?
I asked him how much coffee he had brewing.
Exactly. That's exactly it. Yeah, we've been known to stay on for more than 3. I think last week's call was more than 3 hours, but we like to be considerate of people, so and not wear out our welcome. So it's really any time you'd like to give us past that first hour would be wonderful, and we'd appreciate it. Yeah. So.
Well, the reason that I asked that question because it's really quite difficult to try to lay this out in any reasonable manner in an hour's time. I mean, my seminars are 8 hours, and even then it's difficult to get through all the information, and I'm not going to try to do that tonight because you guys are specifically looking for a little more concentrated subject matter here, so we'll get started. So go ahead.
Okay, sounds good. Just want everyone to know, please mute out, press *6, and we will be going real close to an hour on the lesson itself and without questions. And then if we do have time, we'll open it up for questions, specific questions. So just mute out your phone, *6, and I'll introduce Ron. Ron's a former U.S. Marine and Vietnam vet. He currently works as a professional consultant, counselor at law, has over 48 years of experience on the subject of land patents, mining law, right-of-way, contracts, water rights, and constitutional law. He grew up on a ranch in southern Oregon, educated in engineering, cattle ranching, has a mineral background. Lot of good experiences that helps him tackle some of this stuff that we're facing. Also, he's got several gold and industrial mineral products in the western United States. Currently serves as Vice President of the Southwest Oregon Mining Association, Chairman of the Jefferson Mining District. And Ron, we were talking about you before you came on. We would love to have you come up and meet some of our miners up here at some point in the future. So we hope to get some of that groundwork laid tonight. We have people on that are in the state that have been involved in these property issues for a long time. And so just hoping to get this relationship rolling. And we wanted to focus, like you said, on the how-tos tonight because over the last few shows, I'm getting some interference. If somebody would *6 and mute out. Thank you. The last few shows we have discussed some of the history of the land patent, some of the other things, but and I have referred people over to your seminar in Kalispell that is on Northwest Liberty News YouTube channel with James White. So we wanted people to kind of go there, review your seminars, and then come to the show tonight with a sharpened pencil and piece of paper to write down their questions, but kind of focus on how to do it. But even probably before that, just just to kind of refocus a minute before we get into the how-to, we get a lot of questions about the why. You know, like, what's in it for me? Do you really think this is going to matter? I don't think Alaska recognizes these, kind of all the why should I's around this. And so if you could first address the why.
Well, first of all, pardon me, I think it's really important that people understand it's only with the ownership of land that you have rights. Your warranty deed is not a title. A warranty deed will never be a title. There's no provision in law for a warranty deed to be a title. The only true title to land is an allodial land patent. And so therefore, the benefit, one of many of the benefits that you have by bringing the existing land patent forward, and that in essence is what we're going to be talking about tonight. We are not creating a new patent. That's against the law. That's fraud. But there is provision on the patent document itself, and most of them say it is hereby granted to the undersigned, to their heirs, and assigns forever. And that forever is not up yet. But because of the Administrative Procedures Act of June 11, 1947, we changed from a constitutional republic to a corporate private corporation for profit, and we're calling it a government. And I have never understood why the American people even put up with that. And there are a lot of sharp people in this country. But kind of when a tidal waves come, a lot of people just stand by and kind of, well, let's see what happens. Well, as a result of that, the patent was pushed aside, if you please. It did not diminish its value. It did not diminish its full force and effect or anything. But nevertheless, having said that, but I want to go back for a moment and give your listeners a little bit of a background. Our land right to land ownership is God-given. It's an inalienable right. And I want to read a few things here to you before we get started, just to set the stage about how important our right to own land that is God-given is. And if you'd bear with me a few minutes, let me read you something. And the title of this document is I put together. There are 11 different scriptures in the Bible about the word forever. And I'm going to read these off to you very quickly. Genesis 13, verse 15, for all the land which you see, I will give to you and your descendants forever. Exodus 32:13, remember Abraham, Isaac, and Israel, your servant to whom you swore by yourself, and said to them, I will multiply your descendants as the stars in the heavens. And all this land of which I have spoken, I will give to your descendants, and they shall inherit it forever. Joshua 14:9. So Moses swore on that day, saying, surely the land of which your foot has trodden will be an inheritance to you and to your children forever, because you have followed the Lord thy God fully. 1 Chronicles 28:8. So now in the sight of all of Israel, the assembly of the Lord, and in the hearing of our God, observe and seek after all of his commandments of the Lord your God, so that you may possess the good land and bequeath it to your sons thereafter forever. 2 Chronicles 27, did you not, O God, drive out the inhabitants of this land before your people Israel, and give it to your descendants of Abraham, your friend, forever? Ezra 9:12, so now do not give your daughters to their sons, nor take their daughters to your sons, and never seek their peace, nor their posterity, that you may be strong and eat the good things of the land, and leave it to an inheritance to your sons forever. Move my page here. Psalm 37:29, the righteous will inherit the land and dwell in it forever. Isaiah 60:21, then all of your people will be righteous and they will possess the land forever, and the branch of my planting, the work of my hand, that I may be glorified. Jeremiah 7:7, then I will let you dwell in this place and in the land that I gave to your fathers forever and ever. Jeremiah 25:5, saying, now turn now everyone from his evil ways and from the evil of your deeds, and dwell in the land of the Lord God has given you and your forefathers forever and ever. And Ezekiel 37:25, they will live in the land that I gave to Jacob my servant, in which your fathers lived, and they will live upon it, and they and their sons forever. And my son David will be their prince forever. And the reason that I wanted to read that to you, there's a tremendous emphasis on the issue of God-given right to land. And if you look on every patent that the United States government issued or any of the states issued, every one of them says to their heirs and assigns forever. That means that can be passed down, bought and sold, etc., etc. And in the patent process, and I'll get into that in a bit, you have to prove and show that you are an owner of record. That simply means that whatever way that you acquired the land by a quitclaim deed or a buy-sell agreement or whatever, that you have recorded that in the recorder's office. That stamp on that proves that you are an owner of record. There's a very famous case that put all of this together because there was a lot of attacks upon the patent and the right to bring that forward some years back, and it's called Hooper versus Shimer Case. And in that case, they spell out what it takes for a person to bring their land patent forward. That forever designation on that land patent can never be taken away, it can never be diminished, nor can it be substituted with something else to claim that it has right or priority in its place. And so having said that, then in essence, that's why I spent better part of a lifetime of studying this stuff. My background's constitutional law and engineering, and I saw very early on that we as people in a nation are in trouble because the government's coming after our land. And make no mistake about it, folks, they're coming after your land. And we can get into a discussion after the main part of this tonight if you want, but boy, it's becoming evident more and more every day. Now, having said that, I want to make mention of the fact for the last 35 years, thereabouts, we are losing over 1,200 acres a day to some commercial development or withdrawn designation or whatever. And that just puts a tremendous burden on the people who have land, who are trying to do something with their land. And I want to get into that just a little bit. First of all, most of you have heard the term the police power of a state. Every state possesses that constitutional authority, but it has been terribly, terribly abused. Let me share with you the only time that the state police power can come into play to affect your private property. And that is the issue if what you're doing on your land or with your land is a direct and evident effect upon public health, safety, and welfare. Did you catch that? That's the only lawful authority that the police power has. If you're on your property and you're making bombs or you're making deadly chemicals or whatever, then in essence the police power can be exercised upon the owner and the property. Other than that, there is no lawful provision for code enforcement people that come along. Code enforcement for building permits is absolutely unlawful on its face. The very fact of property, I wrote a book, and I don't know if any of you are interested, but it's called You're Not a Slave. And I prove in that book there that you're not obligated to pay property tax. Private property was never to be taxed. Never, because it's called an ad valorem tax, which means it's a direct tax. And there is no constitutional authority in any of the 50 states, nor the federal constitution, of which it gives them the right to come and make an assessment against you and your private property. Now, commercial property is a different thing, but that's in a different jurisdiction. Private property is under a common law jurisdiction, and it's protected by the Constitution in numerous places. For instance, Article 6, Clause 2, we call it the Supremacy Clause. That has to do with treaty. Patents are protected by treaty law. There isn't a court in this land that can undo or alter a treaty. And you look at Title 42, Section 57 and 83, and it states very clearly that anyone can bring a certified copy of a land patent into any court and all courts in the United States. And the court must take judicial notice of its evidentiary effect. And you're saying, well, Ron, what are you saying? I'm saying when you bring that certified copy in there, that judge is bound by federal law of which to recognize it as a patent and to give its protective covenants that it deserves. Patents and the owner of patents are to be protected, and they're not being protected. Another one's Article 1, Section 10, Clause 1 of the U.S. Constitution. And in that it says, no state may legislate a bill of attainder or an ex post facto law, nor impair the obligation of contract. When the U.S. patents or state patents are issued, it creates, I repeat, it creates a forever contract. That means the issuer of that document is obligated by the Constitution to protect that patent in any and all challenges that may come from that point forward. And they're not doing it. And they're not doing it because we've sat on our butt and done nothing. And I've been trying to get people inspired and educated. I spent a good part of my life doing this stuff. And so I'm thankful for all of you that are interested and want to pursue this, because we need people like you. But the point I'm making, this land patent has got power, because with land ownership, you have and receive and possess a bundle of rights. A bundle of rights. And no one has the authority to take those away, because I just read you the inherent authority by God himself for us to possess the land. That's where the forever comes from. And these land patents come from these 11 scriptures that I just read you. So, boy, you talk about something with authority. I had to laugh. I got a friend of mine in Utah call me the other day. I did a number of land patents for him. He got a huge, huge ranch. And a couple of weeks earlier, a month earlier, whatever it was, he was talking with this attorney. And he mentioned to him that, you know, he had brought his land patent forward. And he said that attorney just got belligerent as heck and told him, he said, there's no such thing as a land patent. And Keith told him, he said, I beg your pardon. He said, maybe you better go home and do some research. Well, about 3 weeks later, give or take, whatever the time was, he said he saw Keith and he said, boy, he said, I owe you an apology. And Keith didn't even remember what he was referring to. And he said, what are you talking about? And he said, that issue of that land patent, he said, man, that's powerful. And Keith told him, yeah. I said, I tried to share that with you. And I only share this story with you folks to show you that it's for real. There's nothing phony. There's nothing that's got a hole in the bucket, if I can put it in that context, about the power and the validity of a land patent. I want to read you something out of my book. I don't know if any of you folks have got your book yet, but this comes from a report that went from the General Land Office to the Congress and the Senate in 1870. And it's found on that report in page 28 and 29. So I'm not making this up. I'm reading it right out of that report. Quote, the individual title derived from the government involves the entire transfer of the ownership of the soil and water and is purely allodial, with all of the incidents pertaining to that title as substantial as in an infancy of a Teutonic civilization. Following in the wake of this fundamental reform in our state land laws are several others which constitute appropriate corollary. Listen to this next part, it's real short. The statute of use was never adopted in the public land states, and hence the complex distinction between use and trust has never embarrassed our jurisprudence. You might be saying, well, what do you mean by that? It simply means that you have free use of your land to do anything that you want to do with that land, provided that you're not endangering your neighbor and that you're not creating a potential hazard to the public health, safety, and welfare. So this code enforcement stuff about a neighbor complaining about your land patent, or your land or your use or whatever has no bearing in law at all. Because here's what happens, folks, and I want you to listen carefully. If we allow that, and the courts will allow it, and the political mindset allows that to happen, when a neighbor can complain to a code enforcement officer who comes out and now infringes upon the open and rightful and enjoyment of your land, that in itself destroys private property. Now, I hope you get the point that I'm making. Because if somebody else can dictate to you what you can do and not do on your land, then in essence, that voids the allodial title. And there's no provision in law for that. And let me share with you what an allodial title means. It means owing to no one, no lord nor superior. In other words, you're the king of your land. When the Constitution was written and all of the I's dotted and the T's crossed, and that it was sent to the Commonwealth of Delaware for the first ones to sign the Constitution, it was lacking 3 words. And those 3 words were inserted by the Commonwealth of Delaware, and the 3 words were, we the people. We the people, and I cannot find, and I've studied and researched until I'm blue in the face about whether they knew what they were doing, they did it by divine intervention or by accident. I don't know, but I like to think that it's by divine intervention. But what that did made you and I, the people of this great land, kings of our land. Government is our servant, not our master. And if we're kings of our land, folks, we better stand up and act like kings instead of whimpering down and functioning as a slave, because that's what they want for you and I. And so we better stand up with absolute authority and jurisdiction, and every one of you have it. By virtue of the scriptures I gave you, by every piece of property that you own, there has an underlying land patent there that's sitting in the archive record of the county recorder's office. Okay? So therefore, it never goes away. And in law, whenever there's any kind of a challenge to you or your property, they're bound by law to go into search of whether you have protective covenants. And they don't do that. They just start filing papers against you and fines against you and all of this other garbage. And I've helped people beat these kinds of cases by the very fact that we pull the patent out that the first grantee filed into the county record. And boy, I mean to tell you, the Gestapos don't like it. So having said that, kind of gives an introduction about where we're going here. So for those of you that are interested in bringing your land patent forward, and I pray to God that you do, I want to say something and to caution you, these must be done correctly. And I want to say that again, these must be done correctly. I read of a court case of a lady in California that did not do it correctly and went to jail for 7 years for fraud. So I'm going to go through here to show you the correct way to do what we're doing. And there are not too many people around the country that do what I do. But most of them are wrong. And I'm not saying that to throw stones. I'm just simply letting you know that they're not done correctly. Okay, here's the first thing that has to be done. First of all, you locate in your file or go back to the county recorder and get a copy of your warranty deed and your buy-sell agreement. Or go to the title company. You can get, if you don't have your own copy or can't find it or has been lost or destroyed. Very important, you must start here. And here's why. On that document, in most instances, is what's called your meets and bounds land description. Meets and bounds means what your township is, what your range is, and what your section is, and where you're located within that section. Now, what I mean by where you're located in that section, and I'm just going to give you an example. Your property is located in the northwest quarter of the southeast quarter of the southwest quarter, or whatever. But it will be something of that vintage of language. That's very, very important, because when you locate that, you want to write that down, get a hold of the Bureau of Land Management Office at wherever they're located in Fairbanks or wherever, for you folks there in Alaska, and you have to give them that legal description. Do not give them, what am I trying to say here?
Oh,
your tax lot number or subdivision number or any of that. That is totally irrelevant, because at the time the issuance of that patent, that didn't exist. Everything is done relative to the patent is done by township, range, section, and where you're located in there. When you have that located, then contact the BLM and order 3 certified copies of that original land patent. And they will have it in the archive record. If for some reason they do not, then contact Washington, D.C. I think it's in Arlington, Virginia, the Department of Interior, Bureau of Land Management, and order it from there. But one of the 2 places will have it. Once you receive those 3 copies of your land patent, now you need to go to the county recorder's office or to go to a title company, and you want to order or to look up and trace back your chain of title. In other words, who owned it before you, who owned it before them, all the way back to the original patent. And that needs to be put in a summary page. And have any of you, do you know, we got the books yet?
Yeah, a few of us have gotten the books, and that.
Okay.
Yeah.
All right.
Yeah.
Let me go to that. Here, just give me half a second, because I want to emphasize why this is important.
And that's the page where it says from the patent who it went to and then who it got.
That is correct. And when you folks get your book, the title in bold letters at the top says Summary of Chain of Title. There's two reasons that you have to do that. You have to show that there is an unbroken chain of title for you to have right to bring your land patent forward, according to case law and to Hooper versus Shimer case. But when you look into it's on page 122 and 123 for those who have your book. For those of you who are yet to get it, you might write that page number down. But you start at the top with the patent and the patent number, and then the patent went to Julius Kellogg, and this is my own patent that I did here. And then to the very right-hand column is the date that transaction took place. So your left-hand column will always be, and I'll call it the seller for the sake of a better term, and then the little word to is to the right of that. The center column is always the buyer. And then the right-hand column is the date. By that I mean the year. You don't need the month and the day. But that's very easy to read, and it shows you exactly the chain of history of your particular land. So once you acquire that information, make up, like I've done in the book here, your chain of title. Then there is the legal documents that have to go have to accompany this. Now, let me list to you what is required and what I call a land patent sandwich for the sake of a better term. You ladies, when you make a sandwich, you put the bread down on the counter, then you put the meat, and then you put the lettuce. Excuse me. Etc. And you build a sandwich. This is kind of the same concept. But the very bottom document, if you're laying them on your counter or your desk, the bottom document will be a copy of that land patent that you got from the Department of Interior. The next document on top of that, and you'll see in the book when you get it, but you can write this down, is a notice document. And it means if there's somebody out there who says, I have a legitimate claim on this property, you have to have your name, you have to describe where you're at, how you can be contacted, and it says in there that you will set the the time and date. All of that pertinent information goes on that notice documents. The ones that I do, and I've revised them somewhat from what I have here in the book, but it's a 2-page document. Doesn't need it any longer than that. And at the bottom of that document, you want to be sure that you sign it. The next document that goes on top of that document there is your summary of chain of title. That can be 1 page. I've had as many as 3.5 pages for people that I've done this patent document with. Okay? The next document that goes on top of your chain of title is whatever document that you received when you bought your property. It can be a quitclaim deed, it can be a tax sale deed, it can be a warranty deed, it can be a grant deed, whatever it is that you received that allowed you to take lawful access to that property. The first 2 pages of that goes here on top of the summary of chain of title. The last document that goes on top is, in fact, and then let me get my page turned here. Get the pages to come apart. It also is a notice document, but at the top it says the United States of America, and in the Republic State of, in my case, Oregon. Yours would be Republic State of Alaska. To the left of that is my name, address, and then Republic USA, and you'll notice that the Republic US is in lowercase and capital for America. That shows that it's not corporate. And underneath that says non-domestic. Underneath that it says notice of. Now this is a certificate of acceptance, and so many people have put just declaration of land patent. That is an unlawful heading for this document, because a declaration of land patent means that you're declaring that land patent by virtue of what you're doing on this document. That land patent has already been declared by its issuance way back in whatever year that it's done. What is required by law is that you have to show acceptance of that. That's why on my documents it says declaration or certificate of acceptance of the declaration of land patent. And underneath that, then I list the land patent number and the date, and then I have the C attached for somebody that wants to go look at it. Then you go through with the items that have to be listed there, that I, Ron Gibson, do hereby certify and declare that I am an assignee in the land patent named and numbered above, and that I have brought up the land patent in my name as it pertains to the land described below. The character of the said land so claimed by in the patent and legally described in reference under the patent number listed above is Township 37, range da-da-da-da-da-da-da. Then I have them listed as 1, 2, 3, 4, etc. Number 2, that I, Ron Gibson, are domiciled at da-da-da-da-da-da. And unless otherwise stated, I have the individual knowledge of matters contained in this certificate of acceptance of the declaration of patent, and I am fully competent to testify with the respect of these matters. The reason, folks, that these are written like they are, this is a legal document. That's what I'm sharing with you. This needs to be done correctly. And the items that are listed in here, and I'll go through the rest of them for you, but there's certain language that is needed, and it's not for press anybody, whatever, but it's for clarity, to clarify exactly what you're doing, what it is that you're accepting, what the lawful description of that is, etc., who the party is or parties, and on it goes. Number 3, I, Ron Gibson, am assignee at law and a bona fide subsequent purchaser by contract of certain legally described portion of land patent under the original certified land patent numbered 1103, dated August 20, 1866, which is duly authorized to be executed in pursuant of the supremacy of treaty law. Remember I told you earlier that the patents are protected by treaty law? That's every piece of ground out there is protected by a treaty. And I'm going to tell you a story about a court case in a little bit. The citation and the constitutional mandate herein referred whereupon a duly authenticated true and correct lawful description together with all their hereditaments and tenements and preemptive rights and apertures thereto, and the lawful and valuable consideration which is appended hereto, and made a part of this notice of certificate of acceptance and declaration of land patent. That's item number 3. Number 4, here's where you have to establish and give recognition about what land that you're claiming. You cannot claim land that you do not own. That's why your warranty deed and the township section and range is so important, because that is exactly what you're entitled to, and that's exactly what you're claiming. Number 4 reads, and I quote, No claim is made herein that I have assigned the entire tract of land as described in the original patent. My assignment is inclusive of only that attached lawful description. The filing of this notice of certificate of acceptance and the declaration of land patent shall not deny or infringe upon any other right, privilege, or immunity of any other heir or assigns to any other portion of land covered in the above described patent number 1103. In other words, you're identifying what your metes and bounds are, and you're identifying what all was conveyed in the original patent. And you're not making a claim to any other of the part of that patented property that was listed in the original land patent. You have to make that very clear. Pardon me. Number 5, this is duly certified land patent is not challenged by a lawfully qualified party having a claim, a lawful lien, debt, or other equitable interest, or in any court of law within 60 days from the date of the filing of this notice, then the above described property shall become the allodial freehold of the heirs or assigns in the said patent. The land patent shall be considered henceforth perfected in my name, and then I put my name, Ron Gibson, and all future claims against this land shall be forever waived. In other words, you're stating that this 60-day period that's required by law for you to post that, and I'll get into all the logistics of that in a little bit, is the fact that they only have a 60-day window if anyone has a lawful challenge. And I've only seen this happen twice, and in both cases, their challenge just got destroyed. Okay? When lawfully qualified sovereign American individual has a claim to title and is challenged, the court of competent and original exclusive jurisdiction is the common law Supreme Court, an Article 3 court. Any action against the patent by the corporate state or their respective statutory legislative units, courts, would be an action at law which is outside the venue and jurisdiction of these Article 1 courts. That's actually Article 1 and Article 4 courts. I've added that in the later version here. There is no lawful issue contained herein that may be heard in any state court. Excuse me. And I said to you before, no state court has jurisdiction. And you're saying, well, why not? I'm going to share with you why not. Because for every state to become a state, when they're a territory, they have to submit to Congress what's called an Admissions Act. That Admissions Act states that they forever relinquish all rights, title, and interest to that property. The reason that that is required so that there's no hidden liens that follows that land into the United States government trust. The government does not own that land, folks. They only administer the administrative part of the people's trust. All lands that are acquired or by conquest or purchase are all put into that trust. The Constitution says that the only land that the United States government can own is military bases, dockyards, ammunition storage, post offices, and other needful buildings. So that's why every land law, and let me digress a minute. I get a little bit upset when I hear people, oh, that's BLM land. Oh, that's Forest Service land. They don't own a square inch of any of it. And I don't know how many of you have heard about the Hague case some years back, but they won that case on the basis the government could not provide a title. I helped a miner win a criminal case by federal charges trying to put him away because, and I proved with his attorney that the government had no title. And I'll share that story with you a little bit later. In other words, every land law ever made is under what's called a public land law designation. It'll say public law, da-da-da-da-da-da. You and I own that land, folks. We own every square inch of it. These wilderness areas that they've withdrawn, totally unlawful. Reservation areas, monuments, none of that has any lawful standing because they didn't come to we the people to get permission to tie those lands up. The other thing about it is all the minerals, and Alaska is rich with minerals. Man, oh man, it's mind-boggling. But in that, under the 1866 mining law called H.R. 365, the mineral is a disposed property by virtue of that act of Congress. It says in that act, in Section 1, that the citizen of the United States has the right to go upon the public domain and search for minerals. Upon a discovery, then you can file on that mineral. When you file on that mineral, it becomes private property. Wilbur versus United States case. So therefore, it has to be protected as a patent. And that's what Wilbur versus United States case says. That duly filed mineral claim acts as a patent. And yet they've been stepping all over miners and citing miners and fining miners and putting them in jail and everything else. Boy, I'm telling you, you talk about a gross violation of the law and rights and congressional acts. So to get back to the point here is the very fact that these cases must be heard in a court of competent jurisdiction. And a state court is not a court of competent jurisdiction. The federal district court is not a court of competent jurisdiction. It must be an Article 3 court because the patent is issued under Article 4, Section 3, Clause 2 of the United States Constitution. We call it the land disposal section of the Constitution. And that has power, folks, let me tell you, because once that patent is issued, there is nothing and that patent can be changed. There are only two provisions in law of which a patent can be rescinded or revoked or canceled. And that has to be evidence of fraud. And the second thing must be clerical error. Those are the only two provisions of which the United States government, in and through their agency, the General Land Office, of which can revoke a land patent issued to the private individual. Corpus Juris Secundum 73b states, and I quote, "Once the patent is issued, neither party can change anything on that land patent, and therefore it must be accepted as read." Boy, that's pretty powerful. And I get attorneys and judges all the time trying to tell me, we don't recognize those anymore. Well, Title 43, Section 57 and 83 says in Oregon, it's ORS 93.650 and 93.680. They have to take judicial notice. That means to recognize what it is, and also its evidentiary effect, that it's total protection of the land. And if you're a landowner by virtue of a patent, boy, I mean to tell you, and I'll get into some examples later on if we have time there later tonight. But the point being is that these items, and then we get into the jurisdiction and the other items that need to be, the last part of that is the signature page. And I've changed this as well somewhat. I like to have you do two witnesses and have the witnesses there when you sign before a notary. And there's several court cases that said that two witnesses are more persuasive than one notary. So what I've done is that I have added the two witnesses and the notary to notarize not only you that are bringing the land patent forward, but the witnesses who are witnessing your signature as well. Now you have 4 witnesses. You have the 2 witnesses that you bring. They have you as a witness, and now you can subpoena the notary. So just call it insurance if you want to call it that. Okay, and I'm running through this like Sherman through Georgia, but I want to go on here real quickly. Once you put all of these patent documents sandwiched together, then you must post it for 60 days in some public building. It can be city, county, state, federal, doesn't matter. But you have to post it for 60 days. And I'm asked all the time, why 60 days? Now we want everything instantly. We want to fax this, and we want to email that, and we want to text this, and on and on and on. Remember, folks, back when this was all put together, they didn't have all of these conveniences that we have today. But as a general rule, the courts then state most everyone came from the countryside to the town or city to get supplies within a 2-month period of time. So that time frame just stuck. And so that's why it's 60 days. Now, before we go any further, on the face of the certificate of acceptance, I want you to take a 3x3 sticky pad. Make it bright color, yellow, blue, pink, whatever. And stick it up about 1 inch on the bottom left-hand corner. Just slide it up and then press the little sticky and then staple it from the left side and come around to the right side, and you have to staple it at about a 45-degree angle. And you're saying, well, why? What's that for? I'm getting to that. On that 3x3 bright paper, you write down the following. This document is to be posted for a minimum of 60 days, depending upon how big you're writing, but right underneath that, then put start date and put what that date is, and underneath that, put ending date and put that date, and then put your initial on it. Now, we've had a lot of trouble with people come along there and tearing those things down. That's a federal offense, number one. But number two, it alerts them, and most people we have found will go and look at that bright colored 3x3 paper. Oh, because you'll give the date that you put it up, you give the date that you put it down, okay, or to take it down. When you go to post this document, take a witness with you, somebody that can take a picture with their camera or their phone or whatever. And then when you get home, then have them do what's called an affidavit of fact, the start of an affidavit of fact. I, John Doe, am over the age of 18 and competent to state and to testify to the following. I accompanied Jane Miller to the courthouse on this date for this reason, to post a land patent sandwich. We arrived at 10:22 and we left at 10:35 or whatever.
Let them go around us.
When you go back, you want to check that about once a week. When you go back to check it once a week, take another copy with you.
Much. I can't believe it. Look at this.
In case somebody has pulled it down. Then you note in your affidavit that when I went back a week later, you put that in your affidavit that somebody had taken that down.
Or are they?
The reason being, folks, you're building what I call a war chest. And if somebody were to ever challenge the validity of your, well, I didn't ever see that at the courthouse. You can prove with your witness's testimony and your affidavit testimony that you did in fact post it. Not only do you have an affidavit of fact, you got a picture of it. And when they go back to pick it up after the 60 days, and I want to qualify something here. Normally, I suggest they leave it up 61 days, not 60. And you may be saying, well, why is that? Because I read a court case that stated that the first day is not a full day. So therefore, your authority and jurisdiction and the effectiveness that starts at midnight at the end of the first day. So to leave it up there 61 days and go. Now, your protective covenants are also effective at midnight and 1 second after the first posting of that. Had a lady up by Prospect here where I live. She was building a hay barn. And there's a major highway that goes by there called Highway 62. And, man, there's a lot of traffic on that thing. But it goes clear over to eastern Oregon, to Crater Lake, and all over the place. And one day a county car come driving in. A couple of guys got out and asked her if she had a permit. She said, no, I don't have a permit. She said, I don't need a permit. And they respectfully but forcibly said, yeah, you do. So she said, what seems to be the problem? And they said, well, you're within 15 feet of the state highway boundary. She said, so? She said, everything on the inside of that fence is mine. Yeah, but you can't build it within 15 feet of a right-of-way. She said, well, and they said, well, if you don't get a permit, we're going to give you 3 weeks. If not, you're going to have to tear it down. She said, well, two things, gentlemen. I'm not getting a permit, and I'm not tearing it down. So you can go back to your office and do what you need to do. So they got in their car and they left. And about a month and a half later, she told me, they came back. They had 4 people in a car at this point. They all got out. They're taking pictures and all of this garbage. And she come out of her home and she said, what are you people doing? Said, well, from the county planning department. She said, so what are you doing here? Said, well, we've come to give you a final notice that you've got another, I think, 7 days to get a permit, or they're going to come and tear this thing down. And she was making a hay barn, real nice hay barn, but it was a hay barn. She said, gentlemen, you just stay right there. I'll be right back. So she walked inside. She got her land patent sandwich. She walked out there to the head guy and said, you better read this. So he pulled the paper up, and all of them crowded around there, and they're reading this thing and pointing to this and pointing to that. And she said, I don't know if you understand that document, gentlemen, but she said, I'm king of my land. And you have no jurisdiction at all to circumvent or to infringe upon something that's protected by treaty law and the Constitution. And they talked for a few minutes. They went over out of where she could hear what they're saying, and they're still looking. And pretty soon the one guy walked back over, handed her the packet back and said, have a nice day. Got in their car and left. And I didn't find out about this till way after the fact. But she told me they never came back. And I'm just sharing that with you to show you that the power that this patent had. Now, is every one of them going to just tuck their tail and go? No, there's not. But I've helped a lot of people that have got this government entity, these code enforcement people, straightened around because they have no authority to do what they're doing. So now let's quickly end up, and then we can get to some questions or whatever. Once you have posted your document for 61 days, then when you go and retrieve it, then go to the county recorder's office and you lay it on the table and you tell them that you want that recorded. Now, we have had in different parts of the country county recorders who seem to think that they don't have and not obligated or won't record that patent. And I can tell you several stories on that. Pardon me. But the fact is, in most instances, they will. If they do not, you take your book with you, and I hope all of you get a book because it's important. And you go to page 127, and the top of the page it says patents entitled to recording. and it gives a whole list of stuff that can be recorded. And land conveyances and titles are to be recorded. It's required by law. Failure to do so will result in further charges under Tweed and Carmaine doctrines. Those are two federal court cases for fraud and estoppel to prevent you from engagement into future commerce. The federal statutes, and I want you to write this down, it is required by federal law under Title 18, Title 18 USC, stands for United States Code, Section 2071. And the court case of that is Biffle, Biffle, versus Morton Rubber Industries. It's a 1990 case. Now let me read to you a short paragraph underneath that. An instrument, that means your land patent document or whatever, is deemed filed in law, filed at the time that it delivered to the clerk, regardless of whether the instrument is file marked. Okay? You're saying, what's that mean? That means that if you take it there and they don't want to do it, you lay your copy on the counter. Do not let them give it back to you. Now, I'm going to tell you a story, because they're required by federal law under Title 18, Section 2071, of which to record that. They cannot damage that document. They can't throw it in the trash or anything. That's a federal offense. I helped some people, pardon me, put together land patents. There were a couple. There were 5 of them, total of 10 people, 5 different patents. They went to the Grants Pass recorder's office to record it, and the county recorder said, I'm not going to record those documents. Of course, they like to add a hemorrhage. This was on a Friday. They called me up, and I said, all of you meet me at the county courthouse on Monday morning at 10 minutes to 9. They opened up at 9 o'clock. So we all met there, and I said, when we get in there, I said, let me do the talking. So we went in, and the gal came up, and we're all standing at the counter, all 11 of us. And she asked us, she said, can I help you? And I turned to her, and I said, Miss, I said, I want you to ask Mr. Harvey, Art Harvey, to come to the counter. Well, I'm sorry, but he's busy. I said, Miss, I think you misunderstand me. I'm telling you, ask Mr. Harvey to come to the counter. So she looked at me to see if I was serious, and I was. And so she went back and talked, and then all those offices back there are glass, at least from about waist high up. And he turned and he looked up there, so he got up and very disgustedly he came to the counter and said, how can I help you? And I said, Art, I said, my name's Ron Gibson. And I said, I represent these people here, and I understand last Friday that you refused to record their documents. Is that a fair and correct statement? Well, he said, yeah. He said, I can't record that. And I said, may I ask you why? He said, because, he said, it's not in the state statutes. I said, really? I said, Mr. Harvey, I said, have you looked up ORS 9650 and 9680? And he looked at me like a deer in a headlight. And he said, no. He said, what's that? And I said, that's a requirement for you to take judicial notice of these land patents. And I had my book, and I turned my book, and I said, would you please read this right here under federal statutes? I said, it says that the requirement to record is under Title 18 USC. I said, that's a federal criminal code. I said, do you realize that you have just committed a federal crime by refusing these people's to record their land patents? And I said, here's the case. And then I read him what I just shared with you about an instrument is deemed in law to be filed, whether it's file stamped or not. He spun around, he told the girl he said record their documents, and walked away. And the only reason that I bring that up to you is that you not only have the documents with power, but you kind of have to have a little bit of groundwork about what to do with it. Okay? So that kind of is it in a very quick Reader Digest version of what to do with land patents. Much more to this, but that gives you an idea what needs to be done. Do not do a land patent using the heading of a declaration of land patent. You must accept it by law. So you do a certificate of acceptance of the declaration of land patent. So, okay, any questions, comments, criticisms? You can throw stones now.
I am going to open it up for questions, but I just wanted to reemphasize that what you're saying, I think I heard you say it somewhere else, that if this is phrased right, it's about jurisdictions. Your warranty deed is in the commercial jurisdiction, and you're bringing it back into the land jurisdiction.
That is correct.
So
you're taking it out of administrative jurisdiction and putting back into common law jurisdiction, because that's where the patents came out of. That's why forever starts at that point, and under corpus juris secundum 73B, nothing can be changed, so that jurisdiction can't be changed. It's common law from start to finish. Pardon me.
Okay, and just again, another point I would like to emphasize here, a lot of us are correcting our status so that we are not coming under the presumption that we're commercial persons, that we're just landsmen or statesmen. We don't agree to be a federal citizen.
You're a sovereign, what you're saying. Right? You're a sovereign. You're a true sovereign.
Right. Somebody who was born a national on one of the states, or whose fathers was born a national on one of the states, not a U.S. citizen, municipal, or territorial. So
that is correct.
Okay, so you agree with that? Okay.
Yes,
and then
I do.
Okay, and the last thing that you said, declaration of land patent, I think that was the title at the top of our land patent, and one of the statements in the declaration is we accept we accept and bring forward patent number blah 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 in my husband's capacity as man. Anyway, you have that. We'll get you a typewritten copy of that. But I just wondered why that heading is wrong.
Why it is? Because in law you have to accept the declaration of land patent. Otherwise you have no proof, in fact, that you're trying to bring your land patent forward. Because remember, this first document, the 3 or 4 pages, whatever yours ends up being, is a legal document. And you have to specify what it is that you're dealing with. You're dealing with a pre-existing land patent, and that's numbered and identified and the date, and you're also identifying the fact of who you are that's accepting that forever benefit in it, and also the very fact that you are proving through that certificate that you're only accepting your portion. It's kind of a twofold. You're accepting the whole patent document, but you're segregating out what exactly it is that you're claiming, because that's all you can claim.
Right. Yeah, and I'm sure it was in there. I'd have to go back and look, but I wanted to see if Chris had any particular questions on his state land patent.
Yeah, I had I had filed a cover sheet with the recording district, and I had mine titled as Acceptance of Title, U.S. Ceded Patent, State Patent Deed et al. Of allodial title acceptance.
Yes, that suffices, because you're designating that you're accepting it, and there are court cases on that very issue. You cannot bring a land patent forward unless you accept what it is that you're bringing forward. That's why you have to identify what it is that you're claiming as far as your part of that original patent.
Right on. What I did, I kind of made me a packet too here. I had originally gone through BLM and gotten a list of what was required, what they had on there for information, and their patent examiner had forwarded me a list, and I kind of used that as a guideline. That was before I had ever heard about you a couple years back. And I had started with that, ended up with the next document was my statutory warranty deed that I was issued from the prior and the very first owner. I had done a replacement deed of private property, re-describing of the property, getting it out of the lot and block description. The third document I had placed in order was a copy of the State of Alaska patent, followed by the U.S. ceded patent. And I kind of put it in like that, but they didn't like it so much here.
Well, as long as you are identifying the property correctly, what was originally issued, so that you can identify what part you're claiming, and you're accepting that. Because what you're doing is you're accepting the benefit of that original patent. That's all that you're really, if I can use the term, taking on or need to be concerned about. Every other previous landowner has relinquished their right to bring this forward. So they can't, somebody that owned it 15 years ago, and I'm just picking a date, they can't come back now and do what you're doing. They've relinquished that when they sold the property. That's why you have to show that you're an owner of record.
Yeah, I'm still on there, and they kind of they ejected me from my own land. So I've got some future work to do yet, obviously, but it seemed like they just ignored it all and moved on, even though it was filed.
Well, they better not ignore it, because there's some pretty serious consequences about doing that. To ignore it is the rejection of what the patent stands for in the Congressional Act, because that's what it is. The patent is by act of Congress that's mandated by Article 4, Section 3 of the U.S. Constitution. That's protected by treaty law, and it's enforced by treaty. And I don't know how many of you have ever heard or not, but there's a very famous case called Suma Corporation versus State of California Coastal Commission, 1984. And in that case, the state claimed that they had right to take away Suma's property in the lagoons that went down to the edge of the Pacific Ocean to give the public access to the beach. And Suma Corporation said, no, you're not getting that land. So anyway, they went to court. The state court ruled in favor of the state. The Supreme Court ruled in favor of the state. The Federal District Court ruled in favor of the state. The Ninth Circuit Court ruled in favor of the state. And finally, it ended up before the Supreme Court. The Supreme Court said, whoa, just friggin' whoa. And they said something very, very interesting in the ruling in that case. And they stated, and I quote, for the state of California to lay claim to that land, the lagoons to the Pacific Ocean, they must be named on the original land patent or be barred. That means, Katie, by the door, state of California, you're out on your ear. And it talked a lot about treaties, Guadalupe Hidalgo treaty. that the United States government and the courts have to adhere and acknowledge and accept those treaties. And that property in question was part of that treaty. So that treaty law is important here, folks. And I've helped a number of people. When you got a code enforcement guy coming along, take your patent and hold a name up there and said, where's your name on this patent? And if you're not named on it, then you have no standing, and it's called privity, of which to make any kind of a claim or assertion or try to enforce anything. I'm the king of my land. Okay, anyone else?
Hello, Ron. May I ask a question?
Go ahead, John.
Okay, I'm looking at the patent that needs to be brought forward.
He needs to speak up. I can't hear him.
Oh, well, let me,
He'll probably have to increase his volume on his computer. It'll take a second.
Okay, that should be better, hey?
Yes, much better. Thank you.
Thank you. It says here on the patent, it says accepting, or a copy of the patent, accepting and reserving also to the United States, upper and lower case, all the oil and gas in the land so patented. Is that valid? I was thinking that the United States government cannot own land or minerals. Is that true or not?
That is correct. That there came after the fact, and that is a breach of their fiduciary duty and a breach of the grants of Congress. The minerals were disposed in 1866 and 1870 and 1872. But because they knew there was money there, they tried to hold those out by virtue of claiming that they had a right to those. But in law, they do not.
So how does one go about getting that overruled, so to speak?
Well, you'd probably have to institute a class action suit, simply because the old saying, the longer something exists, the more lawful it becomes, because nobody objects to it.
Uh-huh. Well, that would be a good thing for us when we're settling Alaska to deal with, then, wouldn't it?
Well, it would. The problem that you have in there, that it's set so long, and now that you're going to affect their pocketbook, they're going to squeal like a pig under a gate. I'm just telling you what the law says. Since when is the government law abiding? That's the problem we have.
Yeah, I can understand, but the status of the patent, that seems like a serious breach of the patent concept.
It is. You're absolutely correct. It is a breach, because under patent law, when you're issued a patent, unless there is specific reservation in the original patent, it's called the Noble decision. Noble was the head of the U.S. General Land Office, and there was a lot of conflict between the farmers and the miners. And finally, he decided to implement one of the rules, and the General Land Office had broad discretion about setting up the rules and how this whole patent issue was to work. And he stated, and I quote, "If minerals is known to exist prior to the issuance of the patent, then the mineral does not pass with the patent." That's what it ended up being. So before that, everything else was, but if you patented a piece of land, then you got everything, above and below. Same thing with the water. All water within your patented ground belongs to you, whether it's on the surface, whether it's subsurface, a well. Here in Oregon, they've been trying to put meters on our wells, and I've written several letters to that effect and asked them for them to please provide their title to the water. Well, guess what? They don't have a title to the water. It goes with the patent. There's a stream that runs through your property. You have a right, what's called riparian rights. You can't take it all, but you can take a portion by putting, it's what's called by appropriation. So any water that you want to drill down, that belongs to you. But getting back to the mineral issue, that's a disposed property by virtue of the three enactments of Congress, 1866, 1870, and 1872, called H.R. 365.
So are you saying that the H.R. is it 365 or H.R. 65 validates their reserving the rights of the oil and gas and so forth to the government? Or are you saying
well, it does not specifically state the oil and the gas. It talks about mineral, and oil and gas is a mineral.
Right, yeah.
So it only when you get in the hands of an attorney who wants to create a controversy do they start trying to split hairs. A mineral is a mineral.
Yeah.
And it says at the end of that the mineral is reserved to the people of the United States. See, there's where it gets crossways. Did you hear what I just said? Who owns the mineral? You and I do. The people.
Right.
It's our land. It's our mineral. This garbage that the government can lay claim, it's like flipping the Federal Land Policy Management Act. I just see red every time I get on this subject. In that document, they say, well, we're going to reclaim those federal lands. How do you reclaim something you never owned?
Right.
That's my question. I want to see your title. They don't have a title.
Well, it seems as though when we establish the government for the Republic of Alaska, that will be valid material for us to be concerned with. I yield.
Thanks, John. I think April has a question.
No, I have no question right now. I'm just listening. Thank you.
Oh, okay. Sorry. Bill thought you had a question.
Oh, that's okay.
Okay. Other questions?
Well, I have a question now that you mention, if I may.
Okay, go ahead.
I live in California, and the county clerk's offices don't want to record or file anything unless the people at the desk approve of it, and they're not lawyers, and I end up actually recording things in another state where the county is gracious enough to let us do that. And I don't know if you've ever come up against that kind of thing. That's what I have. Thank you.
Yes, I have. I've come up with that a lot. And the basic answer to that is you need to challenge them on the basis that they are not authorized to make determinations of law. They're not the state legislature. Pardon me. So the very fact that they're trying to tell you that they don't, or it's not in statute, the land patents are not under statute to start with. The statutes cannot infringe any kind of restriction upon a land patent any more than code enforcement can enforce anything upon a patented piece of ground. But most of those people do not understand jurisdiction. They want to put a blanket over everything and claim that they have jurisdiction over it. That is simply not true.
Hey, Ron?
Yes.
Not only do they claim to have jurisdiction over it, but once you file something with them, they claim total ownership to the point that you cannot withdraw it from them.
Well, you can withdraw anything that you sign your name to, and it's called a revocation of signature for cause. You can do it on a mortgage. You can do it on any kind of contract that you sign.
Well, if it's your own document and you find that they have defrauded you by it, you should be able to withdraw it for cause, should you not?
That is correct. That's what I'm saying. What you do is you draft up in your own words, but the title needs to be called revocation of signature for cause, and state that on this date I had this document. That I had this document recorded because of newly discovered evidence. It is evident that I need to withdraw that document. They have no authority of what's not. That's your document. You brought it. You signed it. You submitted it. You paid for it. That's yours. Those are only for public records or for public viewing. The public doesn't even own that. You do.
Ron, the county recorders and up here the recorder's office, because they've incorporated, the governments have incorporated, they're coming under Uniform Commercial Code.
That does not affect the patent.
Okay, that doesn't affect the land patent, but what about, okay, and I think maybe what we've had some problem with is some other declarations regarding our own status. You know, if it's a document about you're trying to record something and give notice. The other thing I've heard is if you use a notary public instead of a public notary, now you've kind of entered that, again, that commercial jurisdiction. You know, some people take...
Go ahead.
I was going to say, you know, some of the people that we've worked with take it so far as to say if you use any of the statutes, you're entering their jurisdiction. It's like a trespass, or you know, when we're I can't remember, you're crossing over from our jurisdiction as, you know, nationals or people of states or sovereigns. You're any kind of indication whatsoever constitutes that you're accepting that jurisdiction.
Well, that is not true. Let me give you an example. I'll hold your thought there, but I think it's important because you bring up a very good point. Let me give you an example. I quoted you a little earlier, Title 43, Section 57 and 83. Remember me saying that?
Oh, yeah.
And in that it says that any certified copy can be brought into any court and to all courts in the United States, and the courts must take judicial notice. Now, here, you can use the statutes if it reinforces the validity of the patent. You're not crossing over that jurisdiction into there. You're reaffirming that something that is an administrative posture has to reinforce and support the patent. That is not changing your jurisdiction. You're simply using an administrative acknowledgement of the right of that patent and the power of that patent.
And they have to, you're saying they have to come under their own, they have to come under the statutes that regulate them as commercial.
That is correct. That's correct.
That's what I believe. I'm just saying that I've seen, we actually spend a lot of time doing kind of old-fashioned writing so that it would be very clear by the way we were acting that we were only to be considered land jurisdiction people, that we only have one superior, and that's our Creator, and we're not agreeing to come under some other jurisdiction, under this civil law jurisdiction, because we want to stay away from that stuff. So it's a little frustrating because it kind of ties your hands. And also it makes it difficult to communicate with people who only think, in those kinds of terms. They only think in statutory terms.
Well, that's what they've been taught, and you're right. But I want to share with you folks, if I may, real quickly, I want you to write this down. This is a court case in Texas called City of Dallas versus Mitchell. And in that case, the court was very, very clear. And it says, and I quote, "Our rights don't come from government. Our rights come from our Creator. And therefore, we are not subject to government rules and regulations unless we choose to be subject to those rules and regulations." Did you hear what I said?
Yep.
We all think, have been indoctrinated, that government comes up with this garbage and that garbage, that we have to carry that on our back. That is absolutely not so. Because when you're a sovereign, we're sovereign by our Creator, Almighty God. We're sovereign because we're American. And the government, and go ahead.
I got the City of Dallas versus who?
Mitchell.
Who?
Mitchell.
Okay, Mitchell. And do you have a case number?
I don't have it here in front of me, no.
Okay, that's close enough. And how do I get a copy of your book?
Just send me a check to money order, or if you have a PayPal account, and just the book's $45, and I'll give you my address, Ron Gibson, 815 North Central Avenue, Suite D as in David. That's Medford, Oregon, Medford, Oregon, 97501. That's Ron Gibson, 815
90501.
97501.
Okay, I got it. 97. All right.
Got another question for you, Ron. This is Chris again.
Yes, Chris.
One of the things that's been on my mind, I've kind of been looking into, is they've kind of hidden the fact that we can claim land up here in the state of Alaska, and gone as far as writing the governor. And I think a little bit of it was hinted at in his State of the Speech Union this year. But in looking through some of the mining stuff, it basically alludes to going out and staking and claiming land, hard period. And we know what a hard period is. And then it says, come to us and let's figure out how we're going to charge you for it. So I'm kind of curious as your thoughts on homesteading or mineral claim or whatever, taking it from the raw and moving it into a patent.
Well, they put a moratorium unlawfully, like government does everything else, in 1994. Bruce Babbitt was responsible for that. Totally unlawful to do because they never changed the law. They did it under an Appropriations Act. In other words, money. They claimed they didn't have the money to process the patents was the grounds for not doing it. There's no provision in law for them not to do it. In fact, they're mandated to do it under Article 4, Section 3, Clause 2. So the issue of what the corporation tries to do, 99%, if not 100%, of anything and everything they do is against the law. How many of you have heard the term, boy, we're going to adhere to the rule of law. We're going to enforce the rule of law. We're going to pursue the rule of law. What a crock of horse crap that is. You know what rule of law is? It's a rule they're perpetrating to be a law, when in fact it's nothing but a corporate rule. Pardon me. You and I are not bound to corporate rules, like the City versus Dallas case says, unless you volunteer. If you volunteer, then you're obligated to whatever you volunteered to. But we all are sheep, for the most part. Oh, they say jump off the cliff? Okay. When's my turn? We need to wake up. We need to look up to the Lord and step forward. Because if we don't, folks, if we don't, they're going to come and take it. And I want to share something with you here. I have the documents. In 1922 or 23, excuse me. The American Bar Association joined the Communist Party. Okay? And in doing so, they adopted all of the 10 planks of the Communist Manifesto. And the first item on the list of the Communist Manifesto is to abolish private property. In addition to them taking on that decree, the communists said, we want you to take on 2 other items in conjunction with item 1. And that is, we want you to divest the people of their rights, their money, and their property. That's why these attorneys are selling people out. That's why they're helping them lose their home. When you hire an attorney, unless you just get lucky as can be, they're going to sell you out, because that's their oath. The British Accredited Bar Association is a foreign entity. They're not even United States citizens. They're foreign agents. And here we are. Have you ever wondered why an attorney charges $300-400 an hour? It's to accomplish that agreement in 1922. When you divest the people of their money and they can no longer go forward, it's easy to manipulate them so that they lose.
Ron, this is April. I have a kind of a question that's on the outside or on the edge of this. It seems like, in real life, when we come up against these kind of things, there's some sort of immunities that these people seem to have.
They don't.
Like, they don't, but they act like it, and then they can be provocative. Like, you've got a sheriff deputy standing there, like, and it's like, I mean, what's a good action? I mean, to threaten them with, their oath, and I mean, it's kind of provocative to do that. What's the wise way to begin it without and leave, without fighting, but put it in action to turn it around,
Well, that's a very good question, and I have an answer. One of the simplest things for the average man or woman to do is to file a suit in small claims court. Now, I don't know how much it is in Alaska. Maybe some of you know. But here in Oregon, it's $15,000. And if you have somebody that is in breach of their fiduciary duty, then you sue them on that basis. You make public records requests, see what their training is, what they're trained in, what their limits are, It's a little bit of homework, but not much. Because and I don't know how it is in Alaska, but here in Oregon, the moving party and the defendant cannot bring in an attorney. You have to go there on your own. I love that.
That's a higher level of small claims, right? What is it? It's above $10,000. What's it called? It's less than $25,000, right? The type of small claims you're talking about.
Yes, I am.
Okay.
And the reason that that's so effective, see, it's like somebody said a while ago, they claim immunity. They don't have immunity if they're functioning in any fashion outside of their fiduciary duty. I have government personnel and law enforcement telling me all the time, I'm just doing my job. And I jump right in the middle of their mess kit. I don't care about your job. What I care about is your duty. Your job has to fit within the bounds of your duty, not push your duty aside and then go out and create criminal acts against we the people and then claim that you're only doing your job when you get confronted about it. That's when I get ugly. I tell people I'm a good friend, I'm a bad enemy. But your recourse to that very thing is just take your document, here's what the law says, here's my rights, and here's what he did. When you start tapping their bucket, even if it's $500, that word goes through the agencies like wildfire. You'll see a whole different response from that point on. You tap their bucket for $5,000 or $6,000, it really shakes the Gestapo up. Because you have lawful... Go ahead.
No, I was just going to... No, please, go ahead.
No, I'm just going to say that when you have a lawful claim and you can prove it, and you don't have to have a mountain of paperwork to do that. It's like this land patent stuff. They infringe upon that. Boy, what you do is take Title 43 into there and say, Your Honor, here's what the federal law says about what they're doing, and they're not protecting my property. That patent is good forever. They're trying to address an administrative rule or regulation against my lawful patented property. I want to see where they have authority to do that. I want to see their title. They don't have a title.
Are you all right?
Yep.
Okay. Just wanted to ask a question. How much of this do you think is just the going after low-hanging fruit? They know that these laws, the Constitution, the laws are not self-executing, so they're going to try to get away with as much as they can and see if you're ignorant.
But see, that's the problem. We are ignorant. And we're ignorant because we'll watch the 6 o'clock news rather than do a little bit of homework on our computer and My gosh, there's a law library on these computers anymore that knock your eyes out. You don't have to know it all, folks.
No.
You don't have to know it all. Sorry about that. My cough there, they snuck up on me here.
Well, you've been on the phone for an hour and 45 minutes, and I know I said we'll let you go after an hour. So
No, I've enjoyed it. I thank you all for letting me be on the program. I hope that what I've shared is some benefit, and if any of you have any questions, get a hold of me. Glad to help you.
Well, we really appreciate it. I will invite you to come back from time to time, and you can just let me know if you've got the time or if you don't. But this is something that
I'll make
very
time.
much appreciated. Well, that's wonderful. Really appreciate it. We have had some people say, will you work with people one-on-one if they want to, get into some specific issues with their own stuff? And I wasn't quite sure. In your bio, it said you are working as a counselor at law with people?
Yes, I do.
Okay. And what's the best way for people to get in touch with you? Email or?
Well, I'll give you my phone number and I'll give you my email.
Okay, I have those. And I can forward those out.
Then I'll let you pass them out. That's fine.
Oh, okay. Is there one more question? There was somebody who might have had their hand up out there. Wilfred?
Yeah, this is Wilfred. I have a question. Well, first of all, I have a comment. And, I want to thank you, Ron, for, your respect for ideals of the Scriptures and also your knowledge of history and law and other things that you brought forth. I can concur with you 100%. But I have a question about the word abstract. I remember when I was younger, and the land was exchanged, and there was an abstract. There was nothing else, just an abstract. Could that be the same as a patent?
Well, normally an abstract has to do with related basically to history, or that's why they call it abstract of title. The chain of title and abstract of title are in essence one and the same. It means to be able to go back and view, or to go back and see.
And so that is not the same as a patent?
No, it's not.
Okay, that's all. That's what I needed to know. And the other question I have was, I have some land, and eventually I'm going to die off, and I want to give it to my children. Excuse me. I want to bring, they'll want to bring the patent forward. Can it be brought forward in more than one name?
Yes, you can put your patent into all of your children's names, but you do it by a grant too, because that's how the patents are issued. They're issued under a grant. They're called a congressional grant, but you as a sovereign and as a landowner, you can grant that property to your children before you pass away, and just give yourself a lifetime estate on that property until you pass on, or however you want to structure it. But I'm just saying, that way they can't sell it, they can't do anything, whatever, as long as you're still alive. What they do after a person passes, that's open, unless you put a restrictive restriction upon the land that they can't sell it.
In other words, you can put covenants within the patent once you pass it on.
I'm sorry, say again?
you can put covenants within the patent if you pass it on to, like,
yes,
children or
you can. Yes.
Okay. And then could they ever be removed by anyone?
Well, not if you put it's permanent.
Okay.
Well,
right.
if you got, let me give you an example. If you had 4 children and all 4 of them are the recipients of your patent, then it would take, you could say it takes the 3 of the 4 to vote that then they could disperse with the land. Otherwise, it has to be, it can be broken up within the family, but they can't dispose of the property outside the family.
Understood. All right. I really appreciate it, Ron. And the other question I have, you have that I do not have, but I plan to get it. And also, you said you had other books, and I would like to also order them. Are they available at the same time?
Yes. Well, I say I have one other, and my 3rd book, I'm not quite completed yet, but the other book that I do have that's ready for sale is You're Not a Slave. And in that book, I prove that you're not obligated to pay property taxes. But it's based upon you bringing your land patent forward. Because if you keep your property in a real estate designation, that being a warranty deed, then you're subject to taxes because it's a totally different jurisdiction.
Understood.
You have to bring forward your patent, and on that basis, then there's no taxes that can be assessed against your property. That's what that book's about. And it's the same price, $45.
Sure, absolutely. No problem with that, Ron. And, my name is Wilfred Benzing, and I'll be in touch with you as soon as Maria gets out your email address to me. And I believe she already sent the phone number because I tried calling one day, but you were busy or something, and I didn't get back to that.
I'm usually always busy. I have an insane schedule, but feel free. Don't let that deter you.
No, I won't.
Get back to you as quick as I can, but I have pretty hectic days in and day out. So.
Yeah, well, I hope your cough gets better, Ron. I get a cough. I take a little peppermint. I only drink about a shot in a day, and I use about 20 sips to get rid of one of them, and it helps my cough. I was just passing that along.
I got a friend of mine. He said, Ron, he said, a 5th of whiskey will fix that cough real quick. And I don't even drink. So.
I don't either, but I can't really say that. But anyhow, a little nip of peppermint goes a long ways.
Yeah, and I appreciate that. I do.
Yeah.
But anyway, I hope you.
Bless you, Ron, and you'll be hearing from me in good time here without a problem. I appreciate your time here tonight. Thank you very much.
You're sure welcome.
Okay, and sorry about that, Wilfred. I did send out Ron's address and phone number last night with the show reminder, so everybody who's on the call should have it with the show reminder. But the email is drytechrg at, I can't remember the rest of it.
Hotmail.com. Hotmail.com.
So it's DRITEC. Let me say that. DRITECRG at hotmail.com, and I'll send that out, and then I also have the Title 43 excerpts and a few other things that I'll put in. I'll put them in an email and put them down in the show notes. We are going to put this on YouTube pretty quickly here. And other than that, any parting thoughts or words? We'll let you go.
Well, yeah, blessings. Thank you so much, Ron.
Yeah, go ahead.
I just wanted to say thank you very much for coming on.
You're sure welcome. Thank you for all of your patience with me and everything else, and my cough. And but it's very much an encouragement to me, folks, to see that you're interested, because it takes that And we need to band together and start taking a stand. And like I tell people, if you don't, they're coming after it. Mark my words, they're coming after it. And you folks already know that. But by the same token, you know, Jesus said, you shall know the truth, and the truth shall set you free. And we need to proclaim the truth, and that patent is truth. God himself created the right for us to own that land. That's why it can't be taxed, why it can't be encumbered. It cannot be infringed upon in any fashion. That's a collateral attack. And it's an impairment against the obligation of contract. That's a biggie. So.
Very good, wonderful. Thank you so much, and we'll talk with you soon.
All righty. Thank you all very much, and good night.
Good night.
What is it your governors can do? How is it that we have come to thinking and believing that anyone has more to say than you? Stand up, sing your song. Let us know the wisdom of your heart, that you belong, that we belong to you, that you belong to us, and that our love is all untrue. Take that first step and commit to take a chance. Believe, just relax, 'cause no one ever died of trying to take the music back. Just leave it to them others to excuse. Well, state your heart, be yourself. Help us understand it's you and everybody else. I'll take a breath and I'll see it through. You know that I am more myself when I'm standing up for you. How is it that we don't see the pain which we exchange for circumstance made easy to believe in, where everybody's loss becomes a gain? Come forth, reach out your hand, be your brother's keeper this one time. Say he belongs, say we belong to him, that he belongs to us, and that our love is all and true.